I'm going to talk about the planning and permitting laws. Almost every country in the world has an environmental impact assessment law. And in many countries, there is also the ability to challenge the conduct of these laws in court. The legal challenges are typically based on procedural flaws, either failure to conduct an environmental impact assessment at all or in a necessary level of detail, a failure to study certain impacts or follow the right procedures, failure to provide public hearings or other opportunities for public participation. In some places, these lawsuits also include substantive claims, such as the alleged inconsistency of the project with the nation's climate policies. But mostly it's procedural, which means that, at least in theory, if a defective procedure is found, it could be possible to go back and redo it and then get the approval that's necessary, although that can often significantly slow down a project and lead to its demise. Challenges to the environmental impact assessment process are by far the most common form of climate litigation in the United States. Our litigation database at the Sabin Center has identified about 1,600 climate lawsuits in the United States. That's about 70% of all the climate lawsuits globally. Of these 1,600 US cases, about 40% were brought under the National Environmental Policy Act or its state equivalents, especially in California, since states are able to have their own laws. These lawsuits typically concern alleged failures to do the right kind of environmental impact assessment, and if there are also challenges to some of the substantive permits or other aspects of the proposed action, those are typically challenged in the same lawsuit. One common issue in some of these cases in the US, and it's also found in some of the cases in other countries, is the question of whether an impact assessment needs to consider the downstream greenhouse gas impacts of a project. For instance, if you're building a natural gas pipeline, do you also have to present the emissions that will result from the power plant or the factory that's going to utilize the natural gas that is using that pipeline? In the US and in many other countries, one common hurdle to success in these cases is the deference that courts tend to give to the expert judgments of administrative agencies. Though in the United States, the Supreme Court is reducing the deference it gives to our administrative agencies. The final thing I wanted to say is that these kinds of lawsuits can be brought against not only environmentally negative projects, but also environmentally positive projects, such as wind and solar facilities. We see a fair number of lawsuits challenging wind and solar projects based on alleged flaws in the environmental impact assessment process. And there's active discussion in the US of whether there should be partial exemptions from the federal and state environmental impact laws to allow renewable energy projects and other clean energy projects to go through without the threat of this kind of litigation. Thank you.